Hi. So I operate a small patent and trademark practice, um, and this is a really brief primer on intellectual property, just so that you know what the different options for protection of intellectual property are, and just to give you an idea of how they operate, how you can register, and what are the benefits of having some of these registrations. So um, there's a lot of different types of intellectual property, but the registered rights are trademarks, patents, and designs. So patents protect brands. So trademarks protect brands, patents protect the idea or an invention, and a registered design protects the appearance of a product. So we'll go through all of these later, but some of the unregistered rights include common law passing off. So people that have a brand that haven't been registered still have some rights. They're just not as clear as a trademark right. There's consumer law as well for misleading and deceptive conduct. This stops people from using something that sort of coattails off another company in trying to gain benefit from someone else's notoriety. Then there's also copyrights. That's an automatic right for anything you produce that is an artistic or literary work. It stops people from actually copying your work. And then there's also trade secrets. It's an important intellectual property, but it's also one that's very hard to maintain. So even the sort of the big trade secrets like the secret herbs and spices, once it's out and about, it's really hard to contain any of that. So if we go to the next page. So trademarks, the idea of a trademark is to identify where the product comes from, or to consolidate a source of the service or the product. So you're all aware of some of those big names. They're good, strong trademarks. And once you recognize those brands, you know that anything which has that logo on it comes from a certain source. So a trademark can include a word, which is a number, or including numbers and letters, a phrase, a catchphrase example, a logo, but can also include some of the lesser known options of sound, smell, shape, and movement aspects. These are quite, there's not a lot of them, let's say. So they're an option that you keep in mind, but they're also harder to obtain in certain aspects. So if we go to the next page.
And Anthony, you may cover this in the next couple of slides, but do you need to trademark every different, like you could choose what part of your business or logo or brand or whatever it is that you want to trademark?
Yes, we actually do go into this. I've got an example with Shelley.
Okay, excellent.
So for a trademark, there's two sort of key things that need to be considered. One, it has to be capable of distinguishing your products or services from others. So for example, Apple for computers, that when used on a computer, it can clearly be used to separate yourself from other people that manufacture computers. However, you can't get a trademark for Apple for fruit because other people want to use Apple for their apples. This distinctiveness, though, can actually be earned over time. But in that period of time, you don't have protection. So, for example, I've recently trademarked for clients eStore for logistics services and Curvaceous for clothing and retail services. But these are through extensive use over almost a decade, and in which they are the prominent person using that in the industry. The other criteria is that they must not be deceptively similar to another trademark on the register. So this is where other people who register first have a right to maintain that registration and can block your registration if it's deceptively similar. This can be overcome with prior continuous use. So if you've used it for longer than they have registered, you can overcome their trademark and obtain registration yourself, but you can't stop them from using their trademark. So then you have this issue of coexistence. So if we go to the next page, yeah. So the other thing that trademarks have, you have to specify what you're using your trademark on. So the classification system for trademarks divides all goods and services into 35 different classes. And it's my job to interpret what you're using your trademark for and slot them into those 45 classes. That's one of the key things that need to be considered, because cost is based on the number of classes. So there's in Australia, there's 3 options for filing. There's a Head Start application process, which has the advantage of receiving a very early preliminary report on registrability, so within 5 days. Then there's a standard application, which can either be filed using a pick list, so a predefined list of goods and services that are pre-classified into certain classes, or if it's a free-form expression of what the goods or services are. Now, the main difference between these are cost and time frames. So for standard trademark applications, you're looking at 4 to 5 months for a first report at the moment. So you really are in limbo until that gets addressed. And for a standard application using a pick list, you're looking at $250 per class. For a Head Start application, also needing the pick list, you're looking at $330. So for the extra $80 per class, you get a 5-day turnaround for a preliminary report. If you have to handwrite because your pick list doesn't work for your particular goods or services, you just have to use the slow path and spend $400 per class. So we try and avoid that where possible. So on the next slide. So the benefits of trademark registration, it is really there as a means for you to stop others from using a similar trademark. So once you have your trademark registered, you can send a cease and desist letter to someone else that's using a similar trademark. It has benefits over other forms of intellectual property, such as passing off and misleading and deceptive conduct, because you don't have to show that it's misleading or it's deceptive or it's you've had damage or you have reputation. You just have to show that it's a similar trademark for similar goods. So it's a nice, clean, strong protection if someone else is using a deceptively similar trademark. And that's, of course, where the arguments lie. Is their trademark deceptively similar? But depends on the facts. Renewals are every 10 years. So the actual cost for a trademark is all up front, but you actually get 10 years protection once it's registered. So the cost over 10 years is actually quite low. And I consider it more like insurance. You hope never to need a trademark, but it's much, much better to have the trademark registered when someone else starts to copy than trying to retrospectively fix or register trademarks once there is an issue. And I do that for a lot of clients, but it's much easier if you have your trademark registered from the beginning, and you can then block others. The trademark office also, once you have a trademark registered, the trademark office also does a bit of your work for you by not allowing others to register deceptively similar trademarks. So it's also a way of putting in an extra block for others if they're trying to register trademarks. So if we then go to the next slide, we've got to go through these quite quickly. But so we have an example. I've been working with Shelley on her escape room trademark. So in the box, her logo is narrow escape rooms. that can be broken down into narrow because that's the key component of the trademark. Then you've also got the word mark narrow escape rooms, because she uses that throughout the website as well. But then you've got the base of the actual logo, which is the cog and the narrow, and then you've got the full logo. So you can actually get registration for all of these. In this particular case, we filed for narrow as a broad word trademark. Now, we received an adverse report because someone else registered narrow grounds in class 41 on the 20th of November 2020, so just last year. So we have a strategy that we're going to pursue, that is to present evidence of prior continuous use to overcome that. Since Shelley has years of use prior, we should be able to overcome that. Then the only issue then is whether or not the owner of that trademark has used it even earlier. But based on a preliminary look at what they've registered and what they've been doing, probably not. So the next is, we also filed a standard application for narrow escape rooms just to keep the costs down a little bit. So it's pending as well. And hopefully it won't even have the adverse report, because narrow escape rooms and narrow grounds aren't as deceptively similar. But either way, we will be able to use the same evidence. In due course, you could also start looking at filing for one or both of the logos going down the track. But having broad word trademarks is a strong position to start with. So for the next slide, I think we actually, have I got these mixed up?
Covered most of that.
Yeah, we've covered most of that. So it's really just a benefit of having registration as part of your arsenal of to go with your insurances, to go with your business registrations and company registrations, etc. It's just a handy thing to have, and it's something that needs to be continually reviewed. So as you change the way you use things. So if we go to the next one.
And how much roughly for a small business do you think would cost to register a trademark? You know, let's say there's little dispute.
Yeah, so if it's a clean, if there is no adverse report issued, you're probably looking at most businesses probably have two classes, unless it's strictly a retail service or a very narrow service or a narrow good. You're probably looking at two classes. A Head Start application, the official fees would be around the sort of $660. Service charges are, for the filing, probably around $440. So you're looking at around just over $1,000. And then reporting the different processes. So there's usually acceptance, early acceptance and registration, somewhere in the sort of $300 mark. So you're probably looking under $2,000 for a standard trademark for the first 10 years.
But then there'd be your cost. I mean, they're all the costs with the relevant bodies, presumably.
No,
but then there'll be the
$400 is my fee for filing.
Right. Okay. So a couple of like $2 or $3 grand, you can get your a trademark registered and protected then for 10 years.
Also trying to, if you've got a distinctive logo, is analyzing that to see whether or not either the logo with the words or the logo by itself may be worth registering as well. So
yeah, okay, okay. So it's not. I thought for some reason to be a lot more than that, but that's good. It's good to know.
Yeah, so it's not that expensive, and when you think about it, it's divided over 10 years. So your next bill will only be, or next cost will only be at renewals in 10 years, and at the moment it's $400 per class for renewals.
Yeah. Okay, great.
So that sort of covers. I don't know what's happened with mine. Yeah, so patents, we're just going to go through these really quickly because I'm probably already out of time. So patents are a means to protect an invention. Now, often people come with only the barest notion of what the invention is. So that you can't protect an abstract idea, you protect the actual invention. So it needs to be more specific than a abstract concept. You need to know how you're going to embed it into a product or a system. So there are, in the exclusion of abstract ideas, the computer software is one of the ones that are a contentious issue at the moment. Anything that's an app or computer implemented inventions really come down to a technical aspect as well. So it needs to be have some sort of technical element for the office to consider it patentable subject matter. Other things that aren't patentable subject matter are things like games and business schemes. So you can't patent a method of doing business. You can patent the software, a technical aspect of software that implements that scheme, but you can't just broadly cover the scheme. So when you prepare a patent, there's two parts. One is a clear description of what the invention is, both from a legal perspective and also from a technical perspective, so that someone can build your invention from that document alone. So it needs to not just be a really basic description. It needs to be how does someone build this product or system or method, implement the method. It then ends with some claims, and this is a word description of your invention. So most patents will end with somewhere between 5 and 20 claims. And that just defines in words what you're wanting to stop others from doing. So if we go to the next. So patents become very complex very quickly. So there are provisional patents, which reserves rights. There are standard patents, which then start to actually start the process of seeking registration for a patent. You have PCT applications, which are international applications that reserve rights in many countries. So the key is that there are very limited grace periods, and in some countries such as Europe, there is no grace period. So if you publish what your invention is prior to filing a provisional patent or a standard patent, you have no, you can't obtain a valid patent. So it's crucial that when you're starting to get to the stage where you're going to tell others, that's the point where you really need to start looking at a patent attorney to have the as much of the invention recorded in a patent specification as possible.
We've got to move on, Anthony. Is that all right?
Yep, absolutely. So registered patents last for 20 years, annual fees, and the fees mostly in most countries increase over each year. So starting off at a couple of $100 a year up to a couple of $1,000 a year. And that's to make you drop them as they go. If we go to the next, registered designs, this is a very niche registered right. It only protects the appearance of a product. So people, perfume bottles are a classic example. Everyone comes up with a new classic perfume bottle. They don't want anyone to copy that design because that is the signature for the perfume. Registered designs are perfect for that. Registered designs are also good for profiles, things that are somewhere between artistic and utilitarian. The key thing with Australia is that a industrially applied design destroys copyrights. So you can't rely on copyrights if you start mass producing a product. There are some caveats there, but that's a general thing to consider a registered design. If you're starting to mass produce something, it needs to be protected. At present, there is no grace period in Australia, but they are introducing a 12-month grace period. So soon you'll have that similar grace period to register a design. Next slide. So people register designs for the appearance. So the iPhone, the fidget spinner, all those sort of things have registered designs, and it will stop someone from making a copy that looks the same. And again, it has a very complicated process for filing in overseas as well. So next, registered designs typically last about 10 years in most countries. Some have 15 years, some are from registration. There's a bit of flexibility there, but you can pretty much get 10 years out of a registered design. In Australia, renewals are only due every 5 years, so they're due at 5 years, and then that's it for the entire registered design. The infringement, so to stop someone else, it just has to look the same on a side-by-side comparison between the product they are selling and the appearance of your drawing. So, and that's the 3 types of registered IP types.
Excellent. No, that's great, Anthony. And any questions for Anthony? Feel free to unmute yourselves, everyone, and ask away.
Anthony, excuse my ignorance, but can you just explain classes?
Sorry?
Can you explain classes? So,
classes. So I'm not exactly sure where this came into trademarks. It's historical, but there are 45 classes. So for example, retail services, if you want to register for retail services, that's class 35. That
right.
includes advertising, that includes some financial or business aspects. But class 36, for example, then does insurances and other banking and loans, and so anything that you wish to use your trademark in relation to those sort of financial services, you have to register in class 36. Clothing is class 25.
So there's sort of industry groupings
into different categories.
Right. So someone can have the same logo, or have something trademarked that looks similar in 2 different, well, someone can have something, their own logo that looks similar but in a different class, if that person hasn't registered their trademark in that class.
Yes, so generally that's how it works. But some classes have related goods. So it's actually, the comparison is between the trademark being similar and the goods being similar. So for example, some of the classes have very, the office often considers clothing and retail services to be similar because clothing is often sold solely in one store. So if you have a similar trademark for both the clothing and the retail store, they can be confused.
Yep.
But there's other examples where food, for example, is across a couple of classes. So if you register for frozen meals, you may still not be able to get the same trade or a similar trademark for cafe services, or not cafe services, or for meat products, for example. So frozen meals and meat products may be in different classes, but of similar description.
Yep. All right, very good. Thanks, Anthony. We better wrap it up there. I'm just going to stop the recording.